Dobar dan всичко.
Good morning, everyone. Distinguished Mr. Commissioner, Madam Minister of Justice, Head of European Commission Representation Office, dear Dean, dear colleagues, Excellencies, and of course, dear students and other guests attending this event. Good morning to all of you. Today, we have organized an event entitled The Role of the EU in Strengthening Judicial Systems and the Rule of Law. As part of this event, we are going to hold a dialogue with Mr. Commissioner Didier Reynders. This is an event that we are organizing together with the European Commission Representation Office, and it's taking place in order to raise the awareness of students as well as the public at large when it comes to the functioning of the EU. And therefore, we subtitled this event, We Are Going in the Right Direction, from the Faculty of Administration, abbreviated FU, to the EU. So we are first going to hear from the Dean and the head of the European Commission Representation Office, which will then be followed by the Commissioner's speech. And then we will open the floor for discussion. We will ask 3 questions, and then you will have the floor. Please raise your hand if you want to ask for the floor. You can also ask your question via the online application. After you have the mic, please introduce yourselves and ask your question. I would like to invite the students in particular to take the floor. Students of the Public Administration Faculty, Faculty of Social Sciences, and Faculty of Law. I think you have an extraordinary opportunity to hear from Commissioner, because the professors cannot give you all the information. For students, please use your digital code. I would also like to remind you that this meeting is being recorded. First of all, I would like to give the floor to the Dean, Mr. Mirko Pičarić.
Spoštovani Didier Reynders, spoštovani.
Distinguished Mr. Commissioner Didier Reynders, distinguished Minister, high-level guests, students and colleagues, I am convinced that in the history of our Faculty of Public Administration, thanks to the presence of our distinguished guests, the qualities of fairness and justice, moral soundness and conformity to truth have never been so touchable as they are now in this lecture room. And while pessimists may attribute this to the mere shaking of hands, the optimists may see this as an opportunity, just as in the film Casablanca. This may be the beginning of a beautiful friendship. I am pleased that the Faculty of Public Administration is continuing its EU-focused activities, both with our study program, which has an EU module, as with the training for the EPSO exams. And this is the continuation of events that started last year with the analysis of last year's analysis of the Slovenian presidency. The EU Justice Commissioner has diverse responsibilities. The world and the EU are experiencing daily changes, and the reasons for this rapid pace of change can be attributed to several factors, including technological advancements, globalization, migration, demographic and environmental challenges, social and political shifts. These factors and other factors contribute to a rapidly changing world that demands flexibility, adaptability, and a willingness to embrace new ideas and technologies. On the other hand, in this changing environment, justice seeks to create stability, predictability, legal certainty, security, trust, confidence, equality, and other values that contribute to the rule of law. Our distinguished guests probably ponder on these different topics which are present in their everyday work. they also have to deal with online hate speech, disinformation, discrimination, and new digital technologies. These are just some of the areas that our guests have to focus on. But since we are now at the Faculty of Public Administration, we could suggest to Mr. Reinders that he devote one of his next lectures or presentations on how to manage justice in the EU without getting lost in bureaucracy or red tape. Another field of interest, especially in the light of the recent events in Slovenia, could be how to effectively and efficiently tackle institutional reforms. This is an area which Mr. Reinders led as a sectoral minister in Belgium, along many other impressive ministerial fields of expertise. There were 6 of them, if I'm not mistaken, apart from him being a deputy prime minister. Now, I think it is best that the commissioner himself shed more light on my assumptions, and if I mentioned the quote from Casablanca at the beginning, let me paraphrase another quote. We'll always have the Faculty of Public Administration, and if Brussels, as the de facto capital of the EU, can't wait, Paris can. Mr. Reinders, thank you again for coming to our faculty. The floor is yours.
Slovenia, and apologies for this. I apologize for being between you and such an eminent guest, but just allow me to just to say hi, to greet you also in the name of the Commission representation in Slovenia. Zato bom v slovenščini nadaljevala. Spoštovana ministrica, kar na hitro, spoštovana.
Distinguished Commissioner, Madam Minister, Mr. Dean, Excellencies, dear students, it is a huge honor for me to have the opportunity to welcome European Commissioner for Justice, Mr. Didier Reinders. Now, the Commissioner is visiting us on the occasion of the 8th EU Day Against Impunity, which is taking place as part of the MLA diplomatic conference. After the unprovoked Russian attack on Ukraine, we have a great opportunity today to think about the EU efforts so that the perpetrators will not remain unpunished and that justice will be done for the victims. Respect for the rule of law is among the fundamental EU values. Every year, the European Commission publishes a rule of law report in which it analyzes the status in the field of the rule of law in the member states. This year, the report will be published in July, and Commissioner Reinders and his colleagues play a key role. Now, this report has turned out to be a significant instrument in the protection of fairness and principles of democracy in the EU. Today, independent justice is invaluable. We are facing many challenges undermining the fundamental rules, and respect for the rule of law allows us to protect our freedoms, and we should commit to Europe on a daily basis. Justice is the fundament and our basic common value. Thank you very much.
Hvala lepa,
Thank you very much, Madam Yuki Erche. And with this, I would like to give the floor to Commissioner Mr. Reinders.
First, to thank the Dean of the Faculty and the Professor Nikolic for such a kind of introduction, and of course our representation here to explain to you what we are doing now in Slovenia. It was a pleasure to start with the Minister of Justice. It was a pleasure, dear Dominika, to discuss already about the rule of law and the reforms in Slovenia. But it's a pleasure to discuss with the professors and the students. So I'm very pleased to be with you and to try to explain to you what we are doing at the EU level. First of all, about the rule of law, of course, and the way we proceed, and I will say some word about that. Maybe after that I will also take some minutes to explain what we try to do to fight against impunity after the Russian aggression against Ukraine. It's very important to be very open to other discussions if you want. I know that there are huge interest about new technologies, AI, and other kind of processes. I want just to insist that it's an important day today because we have seen in Ireland a very important decision of the Data Protection Authority to impose the most important fine on a big tech, Meta, 1.2 billion euros of fine for the violation of the GDPR. And that means not only a fine, but an interdiction to exchange new data with the US. So it's important maybe to see how it's possible to give a very concrete framework for the exchange of data between EU and US, and I'm also working on this because I'm in charge of the GDPR. And so you will see that maybe in the press in the next hours and days, many comments about such a decision. But let me start with the rule of law, which is one of the fundamental values upon which the Union is based. And over the years, we have seen how in some member states, the respect for the rule of law has been seriously challenged. In other words, we can no longer regard it as a given. We need to protect the rule of law, we need to promote the rule of law, and we need to try to install a real culture of the rule of law in the EU. And these developments in some member states have only further strengthened my conviction that it is essential to hold regular discussions on the promotion of the rule of law, both at the national and at the European level. And for those reasons, since 2020, the European Commission has been publishing its annual rule of law report. This report has its objective to bring the discussion of the rule of law to the front of European politics. And so we discuss the rule of law in all the member states, in the 27, with the same methodology, with the same kind of process, and with the same kind of chapters in the report. We try to describe the situation concerning the independence, quality, and efficiency of the justice systems, the fight against corruption, media pluralism, and media freedom, and all the checks and balances in the institutional order in the different member states. And of course, I said for the first time last year, we have put in the report, in the third edition, recommendations to the member states. So very concrete and precise recommendations. And this year, of course, we will come with an assessment concerning the implementation since last year of those recommendations by the member states. And so I have discussed already this morning about the justice reforms in Slovenia, about the way to enhance the fight against corruption. We are waiting for important decisions in the Constitutional Tribunal or Constitutional Court about the new law concerning the public broadcaster. And so there are many different topics that is possible to discuss, but the rule of law report is an important base to do that, and I'm very open if you want to discuss with you about the content. Another important tool that we have to protect the rule of law, it's the conditionality mechanism that we have put into place at the end of 2020. It's also a protection of the union budget, so we want to be sure that there are no breaches to the rule of law having an influence on the budgetary situation and risking to affect the sound financial management of the union budget. And so the regulation requires the assessment to be objective, impartial, and fair, which includes examining several sources, basing findings on set of evidence, and giving the member state concerned the opportunity to express its view. So it's a real contradiction between, it's controversial, but it's a real contradiction between the member states and the Commission in the discussions. And of course, it's very important with the mechanism of the conditionality, on the conditionality to come to some kind of recommendations to the member states and to see how it's possible to try to organize a real response to the breaches that we have detected about the rule of law. And as you know, maybe we have started to apply the conditionality mechanism with the first case, and for the first time with Hungary, because we have some concern about the fight against corruption, and it was very important to ask to the Council to take a decision to suspend some funding going to Hungary till it will be possible to solve different kind of problems that we have mentioned about the fight against the corruption. And now I will maybe explain also that with such a kind of instrument, we have seen real changes in the EU. I was myself, during 12 years, Minister of Finance in my own country. And I must say that, of course, to read the recommendations of the European Commission in a report, the rule of law report, is very impressive for all the governments. But to see that there's a risk, to see the suspension of the funding of different policies is more impressive. And the financial pressure, the budgetary pressure is very efficient. And so we are using the conditionality, but if you are interested, we are also using the recovery and resilience plan that we are putting into place to ask for some reforms. And we don't want to pay any part of those recovery and resilience plan without a full implementation of some reforms. And again, in some member states, is with the request to organize reforms on the judiciary, on the fight against corruption, in the same way that we ask in the conditionality mechanism. So the financial pressure is very important. But I want maybe to say some words about the situation in Slovenia on the basis of our recommendations concerning the rule of law in the country. And of course, first of all, the first chapter is dedicated, I said, to the justice system, and the recommendation involved the need to introduce safeguards on judicial independence in rules on parliamentary inquiry, and to guarantee budgetary autonomy of certain independent bodies. And furthermore, the report highlighted the need for independence of public service media and online safety of journalists, as well as the need to remove obstacles to investigate and prosecute corruption offenses. And again, we will assess in July, we will publish on the 5th of July the new report, and there we will assess the implementation of what we have asked last year. And I will present the report in the Council, so in the General Affairs Council, on the 11th of July. And of course, it's very important to exchange very concretely about the specific reforms. And we have, again, tried to do that this morning with the government, and first of all with the Minister of Justice. About what? Some judicial reforms. Just to give you an example, if we want to reinforce the independence of the justice system, it's very important to think about the different ways to appoint the judges. Maybe it's fine, like it's proposed in Slovenia, to transfer the competence to appoint some judges from the parliament to the president of the state and to the judicial council. But the judicial council is a very specific body, and we want to be sure that there are some safeguards to protect the independence of the judiciary through the composition of the judicial council. And the normal composition at the EU level is to have a majority of the members that they are judges elected by their peers. That real participation of the judiciary in the process for the appointment of judges. And to be very concrete also, to give an example, why not to have some judges appointed by the president, but if it's that, it's maybe possible for the president to refuse a candidate. It's needed to give a motivation and maybe to have a judicial review on such a decision, not to have just a decision without any motivation and any possibility to organize a review. But we are in very close discussion to see how it will be possible to put enough safeguards in the different reforms to go in the good direction, like it was possible to see about the independence of the prosecutor office with some first decision to stop the process from the past where it was possible for the Minister of Interior to give instructions in individual cases to the police. And of course, it was a risk for the independence of the prosecutor prosecution process, also at the EU level, because since just less than 2 years now, we have a new body at the EU level, the European Public Prosecutor Office, and we want to be sure that it's possible for such a European Prosecutor Office to work in full independence. So you see, there are many possible discussions, and of course we want to exchange on the constitutional amendments in Slovenia about such a kind of evolution in the appointment of the judges, and we try also to see what should be or could be the next step in the legislative process about that. And I've seen a real willingness to improve the situation on the rule of law, so we'll continue to work on it. I want just to insist, like in many other member states, that to improve that, it's not enough to have independent judges. It's also very important to have qualified judges, so to have a good training of the judges, and also to have an efficient justice system. That means enough human resource, a good level of remuneration, and digitalization, so a huge digitalization process in the country. But again, I repeat, that's a recommendation for many member states, because again, for obvious reasons, it was maybe possible to digitalize faster the tax administration in many member states than the justice system. Maybe more interesting for the different states to collect taxes than to organize the process in the justice system. But we try to make progress also in the justice system now. And again, so it's very important to work, because we have some principles in the European treaties about the independence of the judiciary, but we have also some principles coming from the Council of Europe, and we are working on this. And so it's quite important to continue the process, and we will come with a lot of new recommendations or new remarks in the report in some weeks now, because it will be at the beginning of July. Let me turn to maybe a topic very connected, very closely connected with the respect for fundamental values, and certainly the EU values, the fight, as I said, against impunity and genocide in the context of Russia's war of aggression against Ukraine. And of course, we need to be sure that we have all the tools to fight against impunity. And what is very important about the accountability is to support all the existing bodies involved in the process to organize the way to collect evidence of some crimes, and then to organize prosecutions and trials. And we are doing that, first of all, with the Ukrainian people. So we try to give a real support to the Prosecutor General office in Ukraine to organize the investigations on the ground, and then prosecutions and trials. And there are already some convictions in Ukraine for war crimes committed by Russian soldiers. That's the first step, and we continue to work very concretely with the Prosecutor General. Will be taking part in the conference this afternoon too. Then we work with member states. There are 16 member states having started national investigations on the war crimes committed in Ukraine due to their universal jurisdiction, or the involvement of some nationals in the different situations, like murders of journalists. Of course, if there's a French journalist killed in Ukraine, there's an investigation in Paris. And Slovenia start also national investigations, and so we try to see how it's possible to support the process. And to do that, we are working with the existing tools that we have, and for a good cooperation of different member states, the most important is Eurojust. So we try to be sure that it's possible in Eurojust to have a smooth process. So we have now a joint investigation team, is the name of such a cooperation between prosecutors, with 6 member states, with Ukraine, of course, but also with the International Criminal Court taking part in the team, and with a good relation, an MOU, with the US Department of Justice. And due to that, it's possible to work on the war crimes, crimes against humanity, but also they've started investigations concerning the crime of genocide. And it's an important step since the creation of such a team. It was in the beginning of February this year. And now we continue to work on this, because we have extended the regulation of Eurojust to be sure that it's possible to store all the evidence about international crimes committed in Ukraine in Eurojust. Because if you store there, it will be secure, more secure maybe than in Ukraine, and it will be possible to exchange those evidence with all the prosecutors in the different member states or in third countries. Then, of course, we are working also with the ICC, the International Criminal Court, and I want just to say that we support the ICC and all the independent decisions taken by the ICC, like the 2 arrest warrants that you have seen about the president of Russia and the lady in charge of the protection of children in Russia, due to the deportation of around 20,000 of children from Ukraine to Russia, with only 300 back to Ukraine now. So we need to pay attention to that. And we support the ICC, and we ask to Ukraine to ratify the statute of the ICC, the so-called Rome Statute, to take part in the ICC process and to continue to work on it. Of course, if we are ready to fight against all the international crimes, war crimes, till the crime of genocide, there is an issue, it's the crime of aggression. This may be the mother of all the crimes, because if you don't have an aggression, you don't have other crimes. It's because there's an aggression against a neighboring country that you have different other crimes committed in Ukraine. And what we have tried to do till now is, again, to put into place a first layer. So with the same joint investigation team that we have in Eurojust, on such a basis, we have created an international center for the prosecution of the crime of aggression with the same participants. And with more Ukrainian prosecutors, it will be possible to collect evidence about the crime of aggression and to start to prepare the process about a possible trial. What is needed to do more is to have a dedicated tribunal to organize a trial. Of course, my preference is to give the competence to the ICC, the International Criminal Court. And to do that, I've asked to the member states to work on an amendment of the statute of the ICC, the Rome Statute, the Article 8 bis, to extend the competence to the crime of aggression, also in such a situation like we have now in Ukraine with the Russian aggression. And Slovenia is supporting this process, but it will be long to reach the goal to amend the Rome Statute. So for the rest, we need to find a way to have a dedicated tribunal, a special tribunal, like if it's requested by the President Zelensky, or a mixed situation with Ukrainian judges and international judges. We are in discussion about that, and we try to do that not only with the member states, but also with our G7 colleagues, to have a very broad international support. We need to have a very broad support to have a real legitimacy of such a tribunal. But I want to insist on the fact on this point that we are doing that during the war. There are many people speaking about Nuremberg, but Nuremberg was after the Second World War and after the capitulation of Germany, not during the war. It's the first time that we are working so fast and so hard on war crimes and other kinds of international crimes during the war. For the moment, you know, but it's important to repeat that Russia is occupying a part of Ukraine. So we are not exactly in the same situation, but we try to work, and we try also to work on another goal. The first goal is to bring perpetrators of international crimes before justice. The second goal is to be sure that Russia will pay for the reconstruction of Ukraine and for the compensation of damage. And what we have done, first of all, it's to organize now a claims register. It will be possible with the Council of Europe to organize a register where we'll receive all the requests for reparation of damage, to know how it will be important to fund the reparation of the damages. It will be more than reconstruction. Reconstruction is a part of the situation, but there are many other damages caused by the Russian aggression to individuals and to businesses. It will be hundreds of billions. To do that, so first is to collect information, that maybe to have a commission to decide about what are the real damage, and then to fund the compensation. And to fund the compensation, we want, again, to be sure that Russia will pay. So it's the reason why you know that we have put into place, I don't want to detail that, sanctions. So we organize the way to freeze assets of oligarchs and Russian entities and Belarusian entities. And for the moment, we have 24 billions of euro of frozen assets in Europe, $9 billion in the US, to be concrete, 7.5 billion of Swiss francs in Switzerland, to give some examples, 6 million of euro in Slovenia, and we try to be sure that we will have maybe the possibility to go further than that. If there are some criminal offenses linked to the people on the sanctioned list, it must be possible not only to freeze the assets, but to seize those assets. So to go to a confiscation, and then there is a transfer of ownership, and it's possible to send the money back to Ukraine. At the same moment, we have decided to immobilize the reserve of the Central Bank of Russia, and there we are speaking of between 200 and 300 billions of euro or dollars, quite the same. It's more in dollars. But just to say that with that, we want to be sure that we have blocked enough resources from Russia to have, again, at the end, a participation of Russia in the reconstruction and the compensation of damage. It's very important to do that. And so, again, I'm sure that it's very important to do the job at home, like we are doing about the rule of law, to be credible when we ask to have full respect for a rule-based international order, like we try to ask to Russia to have a full respect for that, because if we don't do the job at home, like we are doing with the rule of law report, like we are doing with some procedure in Hungary, I'm open if you want to discuss about the situation in Poland too, about the judiciary, how it's possible to be credible when you discuss about the rule of law, fundamental rights out of Europe. And you know, what you ask to Russia is to respect the territorial integrity of Ukraine and the sovereignty of Ukraine. So to respect international rules, like we try to respect also in the EU. So it's the reason why it's very important to fight for the rule of law in the EU, but to fight also for the rule-based international order with all the partners that we have. And we have some support in the US, in Japan, in South Korea, but we have a lot of things to do to convince sometimes some partners in Latin America, in Africa, or in Asia about the way we are working on it. So we have a lot of things to do also in many discussions. But this afternoon it will be also very important to make progress thanks to Slovenia, to the Netherlands, to many other partners in the MLA convention. So a good collaboration between the justice system to organize real investigations and prosecutions at the national level. Because I said we work at the national level like we work at the international level with the ICC, but the national level is very important. And I'm hoping that the next days and weeks, it will be possible to conclude such a new convention of the good cooperation between the justice system in such a field. So let me conclude again saying that it's very important to have many people engage in the protection, the promotion of the rule of law. And I'm sure that after some years in the university, you will have the possibility to take part in such a process in different kinds of professions that you will have to exerce in the future. Maybe I have maybe in front of me a lot of people able in the future to take part in a real protection and promotion of the rule of law at the professional level. But thank you very much for such an invitation and the opportunity to explain to you what we try to do, what we are doing, and what it's possible maybe to do in the future. Thank you.
Hvala lepa za uvodne besede.
Thank you very much for your introductory words. We will continue now with the discussion. At the beginning, we will raise 3 questions. We will start with the question, or with the topic, which was the last one in Dr. Reindeer's introductory talk, and we will give the floor to Mrs. Petra Podobnikar, who is a politologist and a professor at the Faculty of Public Administration. I would like to raise a question with regard to the MLA Convention and the Ukrainian crisis. The MLA Convention represents an important aspect in the context of the developing Ukrainian crisis, and in a way, it coincides with the idea of normative power of the European Union. Is there a danger that the implementation of the Convention might trigger new conflicts with the Russian side, that it may create pressure on the Russian Federation, and that new conflicts may arise or even escalate? So in what way, this is my question, in what way can we understand the implementation of the Convention in the light of new geostrategic power relations between Russia and the EU? Thank you.
But maybe it's important to say that the mutual legal assistance that we try to enhance, it's a long process. It was a very long journey to try to go to a new text. And it's since 10 years that there are discussions on this. So it's not due to the Russian aggression against Ukraine now. Maybe the annexation of Crimea and the first action in the Donbass 9 years ago were also very important about the way forward. But it was at that moment that we have started many discussions. That's the first element. You asked the relation between the EU and the Russian Federation. It's not a proposal coming from the European Union. It's a proposal with some participation of EU member states, it's true, but also with many other countries in the world taking part in the process. And so it's so important to say that we are supporting the operation, but it's not an initiative coming from the EU. And third, it's more general than about Russia. Of course, it will be useful about the situation that we have now, because it's just to organize a better cooperation and exchange between and mutual assistance, like the name is describing, between different national authorities having start investigations and prosecutions for international crimes. And in fact, what is very important to have in mind is that I said that we are working with the International Criminal Court. We try to see what kind of dedicated tribunal for the crime of aggression. But as for the gravest crimes, that is possible to have such an international jurisdiction. But a very large part of the job is done at the national level. In Ukraine, in member states, in third countries, there are, again, investigations, prosecutions, and trials about international crimes. And about the Russian aggression, or about many other crimes committed in the world by public authorities, it will be easier to work at the national level thanks to such a convention. So, of course, we have a conflict with Russia. It's not a new element, because since such an aggression, we have tried to react immediately. But it's not an initiative from the EU. It's an initiative from a very large part of the international community. And it will be very useful to work at the national level in the different countries, not only the member states, also third countries, to organize prosecution of war crimes. And it's important because they give a signal not only to the Russian Federation, but to all the possible perpetrators of war crimes in the future, that they will take the risk to be in front of the justice one day in the rest of their life. And you know, just to give you an example, we are starting now new investigations and prosecutions concerning the genocide in Rwanda or the war in former Yugoslavia, just less than 30 years ago, in mid of the 90s. There were many students that were not born at that time. But for the perpetrators, it's very important to know that for the rest of their life, they have the risk to be in front of justice. And sometimes at the national level, thanks to such an MLA convention.
Thank you. Hvala lepa. Za drugo vprašanje bi prosil.
The second question will be raised by Mr. Berdutsky from the Faculty of Law in Ljubljana. Thank you very much for inviting me, and thank you, Commissioner, for these very interesting introductory thoughts. I found it very interesting to listen to your thoughts about Ukraine, and it was really interesting to hear you talk about legal order based on law. And I hope that this contribution of yours will change the tone that is prevalent in the discussions in Slovenia. So, I would like to raise a question about a certain aspect. When we see attacks on systems that have a liberal base, we often hear an argument about the quality of judges. For instance, people say our judges are not very good, so we should change that. And if we take a look at the practice, the general practice in Europe, we see that the appointment of judges must be made based on their quality, their excellencies. So we really need excellent candidates. So is there a place for institutions, for the EU, to increase the checks and balances, to increase the control over the appointment and selection procedures in the member states in order to guarantee the quality of candidates? Of course, this raises a question of the legal basis and the treaty. But on the other hand, we have to think about the serious problems that may arise through the doubts. For instance, if we think about Poland and the doubts with regard to the appointment of their judges, could we do more about this in this respect?
No, first of all, you're right saying that when you want to install an authoritarian regime, the first thing that you need to do is to attack the judges, the professors, the journalists, and the human rights defenders. That's the main categories that you will try to put out of the game to be sure it's possible to move from a so-called liberal regime that you described to an authoritarian one. Is the reason why we try to take so many initiatives to react against that and to protect the independence of the justice system, to protect sometimes physically the journalists, because we concrete some murders of journalists in Europe in the last years, but to protect also the academic freedom in the universities, like we have discussed with Hungary since a lot of time, and we try also to protect the human rights defenders with a real funding of their activities, with a real protection against multiple lawsuits like the so-called slaps and so on. But to go back to the first category, maybe the judge, why is it so important? The second remark is that it's so important because the access to justice, and certainly the access to an independent, qualified, and efficient judge, because the three are very important, is the only one guarantee that you have of a real protection of the values at the origin of the Union, but also the real guarantee that you have of protection of fundamental rights. If you have any conflict with anybody, the public authorities, business people, or with other individuals, you need to be sure it's possible to have access to an independent, qualified, and efficient judge to solve the conflict on the basis of what? The rule of law. So the law in full compliance with some principles and some values. And to improve that, there are different needs. The first one about the independence is to appoint the judges in a good process. And now, also in Slovenia, we have such a discussion to see how it's possible to give more competence to the judicial council, and to be sure that in the judicial council, there is a real participation of the judges themselves. So, I said in my remarks, a majority of the members, that they are just elected by their peers to take a real part of the process. Then is it possible to assess better the quality of the candidates? So you need to give enough resource to the Judicial Council, to interviews, and to select better the candidates, and to be sure that at the end it's possible to have a good motivation about why you appoint or not one candidate as a judge. And of course it's not enough to have qualified judges. You have to have a good training, and so a good educational process at the universities, and but maybe also with an academy for the judge and a permanent training, because the laws are changing all the time, also at the EU level, and you need to train the judge all the time to have qualified judge, and to have efficient judges. To need maybe to give a correct remuneration, you need to have enough judges and prosecutors, and you need some time to change the procedures, to don't have a too long procedure in the different fields or criminal cases, but also in civil and commercial cases. And maybe it's also important to say that there is a huge pressure now on the justice system, because everybody wants to go to justice for all kinds of conflicts, so why not to try to develop other processes to try to solve different conflicts, mediation, arbitration for the companies, and so on. But again, it's very important to pay attention to that, because it's the first guarantee that you have to protect all the other fundamental values that we have and all the fundamental rights and all the individual rights. And that's the reason why we are paying so much attention in the rule of law report on the judiciary. And before the rule of law report, I will present that to the Minister of Justice next month. We'll publish also the Justice Scoreboard, the comparison with many figures about the different justice systems in Europe. So you're right, it's very important to pay attention to that and to convince citizens and businesses that without an access to an independent, qualified, and efficient judge, you don't have any protection. The day you have a conflict, you are without any possibility to try to solve the conflict in a fair way.
Hvala lepa. Zadnje vprašanje.
Thank you very much. And this is the last question, which I would like to raise myself. We are now in an academic setting, and I would like to expand our discussion with regard to that. So, despite the efforts of the European Commission to strengthen the rule of law, and you described this very succinctly in your introductory talk, we still see that the fundamental values are being undermined, including the academic freedom. For instance, the Central European University was closed, forcibly closed, and the 21 Hungarian universities have been privatized. This resulted in many dismissals of even prominent law professors. So my question is threefolded. First, is undermining of academic freedom an issue with regard to the rule of law? Now, the second question is, how does undermining of academic freedom affect the European educational space, professors and students? And the third question, how does EU fight against this kind of practices?
It's true that it's a real issue to have a breach to the academic freedom and to the organization of the educational process in another way, that we have full respect for the academic freedom, and certainly in the universities and different kind of high schools. And with an influence, of course, on the functioning of the EU system to exchange some students, some professors, and to organize researchers together, because if you don't have academic freedom, it's difficult to have a full confidence in another system that you are in front of us, that are in front of you. And what is possible to do? First of all, of course, we try all the time to engage a dialogue with the member states. It's the reason why now we have such a new cycle with the rule of law report, because we are sending recommendations, we work together to implement the recommendations, and if it's possible to solve the problem with that, it's fine, it's the best solution. But if it's not enough, the dialogue, we have other tools. I've mentioned en passant the conditionality, the recovery and resilience plan. But first of all, I want to say, if we have a problem with a specific situation in one member state, it's possible to go to the Court of Justice. And about the academic freedom in Hungary, to be concrete, it was the case. We have introduced an infringement proceeding before the court. I know that takes some time, like all the procedures before a court in justice. And so we have had a positive reaction of the Court of Justice at the EU level to say, no, you need to agree on foreign funding, not only for the universities, it was the same for NGOs, to be very concrete. And so we have a success about that. But it's not enough, because we have seen, just to give the example of Hungary, that it was possible for the government to put into place some trust, public interest trust, to receive the funding from the government before to give the funding to the university, but to appoint the dean of a faculty, to appoint some professors, so to have a real influence on the academic freedom. And we have said it's impossible to agree on this. And what is possible to do now for the Commission, of course, is to use the financial pressure. So in the conditionality mechanism, we have suspended funding for more than 6 billion euros to Hungary due to the lack of academic freedom, and we have asked to change those rules to don't have ministers appointed for the rest of their life in a trust to manage the university, and so to change that, and to restore a real academic freedom. We are not yet there, but so we suspend the funding. The same for the cohesion programs, so the programs to help the countries to reach the same level of economic development than the average in the EU. We have also suspended funding for more billions of euros to Hungary, for a part, not only for that, but for a part due to a lack of academic freedom. So again, we have the possibility to push pressure, and there are also discussions in the Council, because the Parliament introduced, like we did for Poland, a reasoned opinion about Hungary concerning the Article 7 of the country. That means breach again to the rule of law, and at the end, with unanimity, so it's quite impossible to reach, except the concerned member states, the suspension of the voting right in the EU. So it's an atomic, it's a nuclear sanction, but we are not so far. But we discuss all the time in the Council about the different concerns that we have with the rule of law in Hungary, and certainly academic freedom. So again, and if I may, my last comment will be, we are doing what we have in all different tools to find for the academic freedom, but it's very important that the civil societies in all the member states are doing the same. I know that there are many pressure coming from all the universities in Europe on the Hungarian government to say you need to stop such a process. But again, no, we are doing the job, and now there are many funds suspended before a real change in the way to organize academic freedom in the universities in Hungary. That takes some time, of course, but we have a real possible influence. And they try for the moment to change. We have seen some amendments, but not enough, so we continue to be engaged with Hungary about that.
Preden odpremo razpravo za širši plenarium,
Before we open the floor for discussion, just a follow-up question to what you just said. The conditionality mechanisms that you mentioned, and the case of Hungary and the freezing of 6 billion euro. We have seen the first effects now. The Hungarians have started introducing reforms that you have touched upon. The European Parliament is already protesting. The civil society is also saying that that's not enough. So it seems that the ball is in your court again. What can we expect?
We continue to discuss with Hungary. To be concrete, I have discussed myself with the Minister of Justice and European Affairs in Hungary about some judicial reforms. And they've put a new draft law on the table. Then it was possible to agree on the content of the law, and we are going to the Parliament. The law will be into force on the 1st of June. But that represents 4 so-called milestones in the recovery and resilience plan. There are more than 20 orders about the fight against corruption, about academic freedom, and so on. And so we continue to discuss. So it's true, like it was said by the European Parliament, an order is not enough. It's a part of the job. And so before to pay anything to Hungary, we need to be sure that they will fulfill all the requirements of all the milestones. So what we have seen now is just a positive evolution on the different elements concerning the judicial independence. It was not the main concern in Hungary. In Hungary, the main concern is the fight against corruption, and then media freedom, academic freedom, and other kind of possible violation of fundamental rights, like the law, the so-called law to protect the children. And we are sure that there are some discriminations due to the sexual orientation in such a law. But judicial independence, now we have seen that it was possible to pay more attention to that in Hungary. But it's not enough, it's true. And we don't want to pay anything before a full implementation of all the requests. So they continue to work on it. And it's not only the 6 billion of the conditionality mechanism that they were suspended. They also quite the same amount of money in the recovery and resilience plan, and we don't pay anything before the reforms. And there are more than that, more than 20 billions in the cohesion program that are also blocked. So you see it's a huge amount of money. We are more than 30 billions for a country like Hungary. It's something. And it's the only one way to have a real pressure. If it's not enough with a dialogue, you need to use all the different tools, the Court of Justice, but also now what we have in our hands with such a financial pressure.
Hvala lepa, skratka, kot nekateri.
Well, thank you so much. Some colleagues tend to say that the European ATM is currently closed. I would now like to expand the discussion and open the floor for your questions.
Pozdravljeni.
Good morning. My name is Nika Podakar, and I am a student of the law school. I have a more abstract question for you. Now, during my course of studies, I have dealt with relationships with the member states on the one hand and the EU on the other hand. And I would like to know, what is it that EU member states can do for respect of the rule of law at the EU level? And what can the EU do for the respect of law in individual countries, for example, in Slovenia?
But certainly about the respect of the rule of law in the member states from the EU level, I don't want to repeat what I've said, but it's very important to engage a real dialogue to see how it's possible to implement some principles that we have in the treaties, in the different decisions of the Court of Justice, the European Court of Justice, but also the European Court of Human Rights in Strasbourg, because there we have a set of rules that is needed to put into place. It's the reason why we discuss so much about the independence of judiciary, the fight against corruption, the media, and all the checks and balances, the role of the lawyers, the civil society, and so on in the member state. And so at the EU level, what is possible to do for the member states is to help the member states in the way to implement some kind of recommendations. The goal is not to put into place sanctions. It's not our goal. Our goal is to try to find a way to have a better implementation of all the EU values and the EU standards in all the different fields. That's the way that we are working. And if it's not possible through such a discussion, I said, we are using other tools to try to take more decisive actions before the Court of Justice or in the discussions about the funding of different policies and so on, to push pressure on the member states. Because at the end, you need to know, it's all the time possible for the member states to go also to the Court of Justice. And at the end, it will be a binding decision. And we have full respect for the decisions. But till now, we have had quite positive reaction from the Court of Justice about our position against different kind of breaches to the rule of law in the member states. In the other direction, it's possible for the member states to take part in the process for a better implementation of the rule of law at the EU level in two main ways. I don't want to be too long about that. The first one is to discuss about the rule of law between the different leaders in the council, but certainly between the different ministers. And it's not easy. It's a new process. Some years ago, it was impossible. I've tried in another capacity. And now, due to the rule of law report, we have a real discussion at the level of the ministers on the rule of law. And I've said the next step will be not only to discuss the situation in the member states, but to discuss about the main principles. What are the main methods to organize the independence of the prosecutor office, to be concrete? If we are discussing that, it's possible to implement at the level of the member state, but also at the EU level. Now we have the European Public Prosecutor Office. So why not to apply the same rules? The same when we discuss about conflict of interest. Is it possible to have a legislation at the national level about the conflict of interest, or the register of lobbies, or different kind of other ethics problem? But we need to do the same at the EU level. You have seen the scandal in the European Parliament some times ago. And of course, we need to implement the same rules at the two levels. And the other way is to help us, from the member states, to organize the accession of the European Union to the European Convention of Human Rights, and so to take part in the Council of Europe. We are engaged in discussions about that, but there are a lot of things to solve, and we need to have the support of the member states to do that, because it will be also important to challenge some European decisions before the European Court of Human Rights. There's no reason that the European Union is out of the game. It's an obligation to take part, an obligation in the Lisbon Treaty.
Thank you.
Hvala.
Thank you. My name is Nada Trongshirca, and I am professor at the university in Primorska. And I would like to touch upon human rights, and also something that my colleague from the law school has mentioned, and that's independent and competent judges. Now, speaking about human rights at the level of principle, it's all okay. But I think we need to learn from practical examples. And in order for you to understand my question, I would like to mention a specific case. And it is a case that is a horror in Slovenian judiciary. And I'm also turning to students. It's a boy who was 28 years old, 14 years ago. His family house was destroyed. It was his home. Now, the decision was confirmed by the Supreme Court to protect the illegal action. The prosecutor's office acted and prosecuted this particular individual, and he was behind bars for a year. The prosecutor exercised pressure. He said he was guilty so he could get his weekends out of the prison. But then this privilege was stopped, and he spent 2.5 years in prison simply because he was pointing out what the judicial institutions did. In 2018, the European Court forced the Republic of Slovenia to admit to 4 violations of the Convention of Human Rights. Articles 5, 6, 7, and 8. But it's a farce, and it's bizarre that in that same year, when the case was in the European Court, Slovenia prosecuted this individual for things that were not based on the same case. A year ago, this young gentleman was behind bars for 3 more months. That's a decision of the Supreme Court. Today, this gentleman is behind bars again. A week ago, he was detained again. And I'm speaking like a mom. That's my son. That's Jure. This is happening to me. This is happening to my family in this country. My question to you is, how can we allow such lengthy proceedings which clearly show that we are talking about premeditated illegal actions by the Republic of Slovenia, and we seem to be transferring the pressure to the European Court? Where is justice? Where is respect for the law? Because we are in the hands of the prosecutor's office and lower courts, which can continue to work illegally forever. We have decisions from supreme instances, and we have judgment from the European Court. So my question is, are there any changes on the horizon so that in cases where there are evident violations, in order for the European Court to be able to react quicker to protect human rights and a civilized Europe? And so that the European Court can sanction those who continue to work illegally.
No, first of all, I fully understand your reaction, and so as a mother, about the specific case that you mentioned. Of course, I don't want to comment on the concrete case. I want just to confirm that what you describe, it's an additional reason why we try to develop in all the member states recommendations and sometimes pressures to go to a more independent but also qualified justice system. And not only for the judges, I've said also too from the prosecutor offices and is one of the main discussions that we have to organize at the EU level. What are the rules to be sure that we have independent prosecutor office, but with a real quality and a real willingness to implement all the decisions taken at the different levels. The second remark, it's about what you explained about the European Court. It's the European Court of Human Rights in Strasbourg. So it's not the European Court of Justice. Because when we are going to the European Court of Justice, we ask sometimes to push pressure. Just to give an example about the disciplinary regime of the judge in Poland, I've asked myself to put into place some interim measures to solve the situation. Poland refused to implement interim measures decided by the Court of Justice, and the court decided to impose a fine of €1 million per day on Poland. It was at the end of 21, so we have asked now more than 500 million to Poland. And again, it's a financial pressure that we try to organize. But it's true that what is important now is, I said, to take part in the European Convention of Human Rights. The accession of the EU will be an important part to try to solve that. And it's not enough, but what we have tried to do in the last report, my request on the rule of law, for the first time we have put a sentence in the report about the non-execution by the member states of the decisions of the European Court of Human Rights, because it's an obligation for the member states to implement. I don't want to say that it's an excuse or not. It's not the responsibility of the Commission, of course, to put into force a decision of the Court of Strasbourg. But, just to give you the indication, it's the responsibility of the Committee of Ministers of the Council of Europe. So there, all the member states are, with orders, but all the member states are. And it's very important to try to push pressure to have a correct implementation. It's abnormal what you describe, not on the specific case, because I don't have all the elements, but on the fact that there is no full respect for a final decision taken at the high level, at the highest level, like the European Court of Human Rights. It's the reason why I've started also to conclude a process with the member states to say, I want to have a presentation of the execution of all the decisions taken in justice at the national level too. If there's a decision, are we sure that the decision is in application? Because I said it's important to have an independent, qualified, and efficient justice system. But if at the end, like you have said, the final decision is not in application, you don't have any success. You went, I'm sure, to the European Court of Human Rights. If you have there a positive decision, the decision must be applied in the country. It's a request also that we are putting, but again, it's a decision in the concert of the Convention of Human Rights, so in the Council of Europe, and in the Council of Europe, the pressure normally is organized by the Committee of Ministers. Maybe not enough, so it's the reason why we try to have an access to the convention by ourselves. But I fully understand your action, because you confirm what we try to do. It's very important to continue to work on the independence of the justice system, but also to work on a full implementation of all the decisions taken at the highest level. European Court of Justice or European Court of Human Rights.
Hvala. Naslednje vprašanje.
Thank you very much. Next question, please.
Dobar dan, jaz sem Gregor Durko.
My name is Gregor Durko. I am a student of year 1 at the Faculty of Public Administration. I have one question for you with regard to the prosecution of war criminals in the still topical war in the Ukraine. You have given us an example with regard to the Nuremberg trials in the aftermath of World War II. But I would like to know how the present war criminals will be prosecuted and sanctioned. Because if they haven't been arrested yet, Russia certainly has no intentions to extradite those individuals. So how is this happening? How does this function?
It's already possible to prosecute and organize trials about some perpetrators of war crimes. You have seen that maybe in Ukraine, because there are some soldiers under arrest, and there were some trials and some convictions. After that, sometimes there's also some exchange of prisoners. That's another issue, and I fully understand that sometimes it's better for the Ukrainian people to exchange also prisoners after condemnation to receive back some Ukrainian prisoners. But that's the first element. So there are already some decisions with soldiers in jail, but there are also some decisions in absentia. So with a conviction, but without the presence of the perpetrator. And that's possible in Ukraine, that's possible in the member states too. For the rest, what are the possible pressure? Of course, if you have people staying in Moscow, it's difficult to organize the trial and certainly to organize the execution of the conviction if there is a conviction. But you have seen that, again, during the war, that is new, we have started the process. And due to the specific situation that we have seen with such an aggression, there are huge decisions taken by different jurisdictions. In the ICC, the prosecutor Karim Khan have proposed to the court, and the court decide to issue 2 arrest warrants against the president and the woman in charge for the protection of children in Russia. Of course, if they don't go out of Russia, it's difficult to do something because, like you said, they don't want to organize the extradition. But if they want to move, it's an obligation for all the parties in the ICC to organize the arrestation. So the pressure is huge. And it's the reason why I said in my remarks, what is important is to be sure that we will have the possibility to bring the perpetrators to justice one day. Next day, next week, next month, next year, maybe in some decades. But they need to know for the rest of their life that the risk is there. And what is the difference with Nuremberg or other kind of processes in the past is that now we are during the war. So it's very special. We don't know what could be or should be the situation in the next months or years, but we want to collect all the evidence of international crimes. We want to give all the evidence to all the possible prosecutors. And my job is not to say who is guilty or not. I have my own idea about that. But it's to give to the prosecutors, and again, independent judges, the possibility to do their job, to organize investigations, prosecutions, and trials. And at the end, it will be an independent jurisdiction that will take a decision. Now or later, but we are starting the job, and we will see. Maybe that will take some time. I said we have seen new condemnations or new investigations, and maybe new condemnations about the genocide in Rwanda or the war in former Yugoslavia. It was in 94 and 95. So we are very late. But if you remember, maybe 2 years ago around that, there were again a condemnation of a German man of 100 years old for the Second World War. Of course, it's late. But the principle must be there, that if we start the process, we don't stop. And so one day, it will be possible maybe to see, I don't want to predict, some change in Russia, some change in the leadership, some evolutions. But for the moment, we do the job. Collection of evidence, preparation of prosecutions, and then we will see if it's possible to have a trial.
Urban Ličnik Spajić, Pravna fakulteta.
Uprav Michnik from the Faculty of Public Administration. You have mentioned the appointment of judges. You have mentioned also the amendments to the procedure of appointment. On first glance, this sounds really good that peer judges appoint judges among themselves. So, but on the other hand, we see problems in this respect. We see that some judges really have different opinions, they follow different ideologies and so on, and this has a great impact on their work. This is probably partly due to the relative size of Slovenia. Until up until recently, we only had one faculty of law, so everybody was familiar with everybody. So my question is, how do other small countries face this amendment of peer appointment? This peer appointment may lead to the situation whereby an appointment of a judge would not be done properly. Of course, we want to repair things, but we may do the opposite. So my question is, how do other countries of similar size face this situation?
We have sometimes specific situation with regard to the size of the countries. Just to give you an example, about the media freedom, it's not exactly the same to organize the pluralism in the media in a small country or in a very large one. In Germany or in France, to fund different kind of channels, it's maybe easier than when you need to do that in a smaller country. So we need to take that into account. But to answer to your question, I will take an example. In Luxembourg, they've worked since more than 3 years about constitutional amendments to introduce 2 elements in the constitutions: independence of the prosecutor office, it was new, and the new composition of the judicial council with exactly the same discussions. I've said you need to have a majority of the members, they are judges elected by their peers, and they were close to that, but I've seen that a part of the judges were ex officio, so the president of the Supreme Court, like it was discussed also in Slovenia, said why not to take part, but not as a part of the judges elected by their peers. It's not an election. And so now they are at the end of the process. So they changed the constitution to put that into place. And my additional remark, it's true that it's not so evident to organize the selection and the appointment by the judge themselves. But it's not that. What we have said is a majority of the members of the council, but that will say that the rest of the council, maybe 49% of the members, are from another origin than the judiciary. It's very important to have such a balanced approach, not only judges, but also others. And at the end, what is very important is the transparency. So to organize a selection process with interviews and with different kind of methods, and then to say very transparently the motivation of the appointment of one candidate and not another one. And at the end, to be open to have a judicial review of that again. So if you have concerns about the appointment of a judge or the non-appointment of a judge, that must be possible to challenge the decision. So the transparency is also very important. So again, there are evolutions in the same way in other small, if I may, countries or member states, but it's not just with judges. You need to know that in the judicial council, we want to have a large part of the council with other people than judge. It's just the majority. They must be with a judge elected by their peers. So it's a huge difference. And then the transparency is the most important element to explain why there is a choice for some candidates and not the others.
Hvala. Vem, da bi lahko komisarja zasliševali še dolgo.
Thank you very much. I know that we could raise many more questions for our guest, but he has other appointments on his agenda, so we will accept one more question.
Jernej Pikalo, Faculty of Social Sciences. I have one question for you. You explained many things about both the ICC as well as the Special Tribunal, but maybe you did not touch so much upon the appointment of international judges in Ukrainian courts. Do you see this as an opportunity? Of course, this would demand an amendment of the Ukrainian constitution. So can you assess, not from the legal or technical point of view, but from the political point of view, which of the options, special tribunal, ICC with enlarged competences, or this third option with the amendment of the Ukrainian constitution and international judges? since we are not the only ones, I mean the EU, but we also have global partners, what is your assessment? Which of these three options would be the most useful? And not only useful, which one seems to be most doable and realistic to you?
Of course, it's different. What are the best options? I've tried to explain different times. I will take the same comparison with the Olympic Games, maybe. The golden medal, the golden solution is the ICC. If you have an international criminal court, you need to ask to such a court to organize the trials about all the gravest international crimes, like the crime of aggression. Now it's impossible because Russia is member of the Security Council. It's not a party in the ICC because Russia didn't ratify. They have signed but not ratified the Rome Statute. So it's impossible to send the competence to the ICC without a decision of the Security Council. And you know there's a veto right of Russia in the Security Council. So the first solution will be to amend the Rome Statute to give the competence to the ICC also in such a situation. I've asked to all the member states, and Slovenia is supporting that, to work on it. But it will be long. It will be not overnight that we will have such a golden standard. The silver medal, so the second possibility, is a special tribunal. That means a new treaty to put into place a new tribunal with international judges to apply international law. It's heavy. If you ask for the practical elements of such a solution, that means a new building, new judges, funding of that, new case management system, IT systems, and so on. But it's a new institution. And we need, if we want to do that, we need to avoid any contradiction with the ICC. So it's possible, and it's the request of the President Zelensky. And I will say the bronze medal, so the third solution, is such an hybrid or international solution. So Ukrainian judges in a jurisdiction from Ukraine with additional international judges to apply the Ukrainian law. You said it's needed to change the constitution also for the special tribunal. So in both cases, Ukraine need to amend the constitution, the Ukrainian constitution. At the political level, first what we need, it's a very broad international support to have a legitimacy in what we are doing. So it's the reason why we discuss not only with the member states, but with our partners in the G7, with the US, UK, Canada, Japan, and others. We have to be sure to have a broad support for that. That's the first element. The second element is that we ask to Ukraine to ratify the Rome Statute, because it's very strange to ask a new jurisdiction, but to don't take part in the existing jurisdiction. Because, you know, in a war, there are war crimes on both sides. Of course, in Ukraine, we are sure that quite all the war crimes are committed by the Russian soldiers. But you know, it's a war. And to give you an example, when we are sending peacekeeping mission from the UN with blue helmets, there are some people committed war crimes, violence against women, children, or other crimes. And we need to organize investigation and prosecutions. And there is a commitment from the Ukrainian authorities to say we will ratify, but not now. I continue to say it's important. If you ask to apply the Rome Statute to Russia, you need to be open to see the same application to you. Maybe in very few cases, but to have investigations. That's the second element. The third element, of course, it's the political discussions. And you know that we don't have all the members of the United Nations and also not all the members of the Security Council in the International Criminal Court. There are, to give an example, just a small example, the US are out. And we don't have all the member states on board for the crime of aggression in the International Criminal Court. So again, there are also political discussion, what is the best solution? And for the moment, at the Commission level, again, we have such a vision. We need to move on the ICC, and then we need to find the most important support for one of those two solutions. The preference of Ukraine is a special tribunal. There are many hesitations in different countries about that. What we have said on our side, we want to build a dedicated tribunal to organize the trial of the crime about the crime of aggression. But I said during my remarks, we have started the process. We are not waiting. We have now an ICPA, a Center for the Prosecution of the Crime of Aggression, but where it's possible to collect evidence of the aggression, to store those evidence, and then to prepare a possible trial one day. And again, is maybe the most important thing in conclusion. I know that there are many reactions on this, but I want to insist again on the fact that for the first time, we are doing that during the war. It's quite very new, because normally it's a discussion that we have after the war. And here, there are already some investigations, prosecution, trials, and discussions on the different steps. So we are not late. It seems to be that takes some time, but it's the first time that we are doing that during the war. And I will try to have new discussions, others are doing the same, to have a broad support for the most efficient solution. Special tribunal or not, but a dedicated tribunal for the trial of the crime of aggression.
Hvala lepa. Spoštovani udeleženci, prišli smo do zaključka.
Dear participants, this brings us to the end of this event. I would like to thank you for your participation, for asking questions and sharing views, and also for raising the awareness about the problems that we are experiencing in Slovenia as well. I would like to thank, in particular, the Commissioner, Mr. Didier Reinders. Thank you for coming and sharing your views, and we hope that you have enjoyed this event as much as we did. And I wish you all the best and enjoy your stay in Slovenia.